Hi. So, I'm back. Notice nyo hindi ako nakapag-upload kahapon. It's because I'm sick. And this would be the last episode for Crim Law 1. Ito na yung part 2. Finally. I always say that, pero ito na talaga. Then after this, I might take a 2-week break kasi yun nga, hindi ako naka-aral this week. So I wasn't able to finish my notes on polyrev and property. And I might need to take some time off to rest and focus on my health for the next 2 weeks. But I'll start uploading again on the 22nd of October. And I don't know, it depends. Maybe I can squeeze in some videos next week. I don't know, but I can't promise because I'm gonna be real busy, and then I also want to rest. Because I don't want to burn out and I don't want to abuse my body too much because, you know, I'm studying and at the same time I'm also working. So, yeah. I'm checking out the schedule I posted on the community tab. So, I said here, for October, we will have criminal law review, extinction of criminal liability. So, okay na yun. Kasi ito na yung last installment of extinction of criminal liability. However, may utang pa akong law and property and constitutional law 1. But I'll make sure that I upload everything by October. I usually keep my word. I try my best to. Ayan. I just can't tell which dates sa October, but definitely within October. Kaya yan. Okay. So, last video, we stopped at like the 3-fold rule. We were able to discuss how to offset, how to compute penalties, etc. And then the islaw. Pasensya nyo yung boses ko if it's different, if I sound different. Kasi, may plema. Yeah, but I'm feeling better na compared last time, like few days ago, like Tuesday, Wednesday. Grabe, I really had this fever, so I'm feeling quite better compared to yesterday and compared to the first days of the week. So, anyway, when is criminal liability partially extinguished again? Partial lang, hindi total. Kasi pag total, you will have death, for example, that totally extinguishes criminal liability. What else? If there's amnesty or absolute pardon, mga ganon. But let's just talk about how or when to partially extinguish criminal liability. So, we have conditional pardon. Then we have commutation of sentence, good conduct allowance, special time allowance, parole, and probation. I think we already talked about good conduct allowance and special time allowance. I'm not sure. So, pwede rin nating balikan mamaya to be sure. Parole, discuss natin yung islaw. Basically, that's it. What is parole? It's a conditional release of a prisoner from correctional institution after serving a minimum period of prison sentence. And I guess turuan ko na kayo kung paano i-determine yung minimum period and maximum period, right? So, yun. Pag na-serve na yung minimum period, then eligible na sa parole ang convict or prisoner. So, yung Board of Pardons and Parole, yun yung nag-grant ng parole to a prisoner. So, it's an office under the Secretary of Justice. And if the parole violates the conditions, the parolee violates the conditions of his parole, he shall be recommitted or returned to prison to serve the unexpired portion of the maximum period of his sentence. Now, I will not be discussing community service anymore. So, for community service, I'll give you a link, or probably, somewhere up there. Or if not a link, then if I can't share a link up there, I'll just link it to description below. So let's talk about probation. So probation law is not a penal statute. Courts have no authority to invoke a liberal interpretation of it in this case, as its words leave no room for doubt or interpretation. Probation is not a right, but a privilege subject to the discretion of the court, and the discretion is exercised primarily for the benefit of society as a whole, and only secondarily for the personal advantage of the accused. So probation may be granted whether the sentence imposes term of imprisonment or a fine only. It may be extended to children in conflict with the law or the CICL. And after convicting and sentencing a child in conflict with the law, and upon application at any time, the court may place the child on probation in lieu of service of his or her sentence on account of his or her best interest. And probation, if he violates a condition of his parole, he will only be required to serve his original sentence, and that is your sentence, the unexpired portion of your sentence, which is the original sentence, which is not the maximum sentence. Kasi as discussed sa previous video, when you say maximum sentence, it is the sentence that includes the appreciation of the aggravating circumstances. So, who are disqualified offenders of probation law? Ito yung mga bawal mag-reap ng benefits or mag-avail ng benefits of probation law. These are persons who were sentenced to serve a maximum term of more than 6 years, convicts of crimes against national security, those previously convicted by final judgment of an offense punished by imprisonment of more than 6 months and 1 day, and or fine of more than 100,000, those who have been once in probation under the probation law, those who are already serving sentence at the time the substance provisions of the probation law became applicable pursuant to section 33 of the same law, and drug trafficker and pushers, regardless of penalty imposed by court, cannot avail of probation law privileges as amended by the Comprehensive Dangerous Drugs Act of 2002. So I might take a short break every after 10 minutes or so, but don't worry about it, because I'll just cut the video and then or pause the video, the recording of the video, and then I'll just resume. So when I upload this, the way you'll watch it is that parang tuloy-tuloy lang naman siya, so no worries. But I'm just telling you guys and girls, because you might notice why parang may cut, no? It's because as I said, I'm not feeling my best, so I might need to take a break like every after 10 minutes or so. Okay, so application for probation. Defendant must file an application for probation within the period of appeal. Again, magkaiba yung probation sa parole. When you think of parole, you think of islaw. This is nasa parang i-release ka if eligible ka once ma-serve mo na yung minimum term. Pag probation, iba naman. Sa probation, the defendant, okay, will file an application for probation within the period of appeal, kahit wala pang final judgment ng case niya. And the effect of filing of application is deemed as a waiver of the right to appeal. So, imbis na mag-appeal ka ng case mo, you're just gonna, during the time that you're allowed for appeal, which will be discussed in remedial law or criminal law, criminal procedure, instead na mag-file ka ng appeal mo, yung i-file mo yung application mo for probation. And the application shall not be entertained or granted if the defendant has preferred the appeal from the judgment of conviction. So you have two choices really if you lose a case and you're a defendant, whether you appeal or you apply for probation. So if the defendant has perfected the appeal from judgment of conviction, bawal na mag-apply for probation. Except when a judgment of conviction imposing a non-probationable penalty, the defendant shall be allowed to apply for probation based on the modified decision before it becomes final. The accused shall lose the benefit of probation should he seek a review of the modified decision which already imposes a probationable penalty. So, filing of application based on modified decision. Application shall be filed in the trial court where the judgment imposing a non-probationable penalty was rendered, where such case has been re-raffled, and if several defendants have taken further appeal, other defendants may apply for probation by submitting a written application and attaching thereto a certified true copy of the judgment of conviction. So, I think I need to take the said break. Okay, so the Dimakuta Decision was issued October 2015, but RA 10707, which amended the probation law, was signed into a law November 2015. And the Dimakuta does not distinguish the ground for appeal of the judgment of conviction. If the judgment is modified on appeal through the imposition of a probational penalty, the defendant shall be allowed to apply for probation based on the modified decision before such decision becomes final. Okay. So, appeal must be limited to the following grounds. First is that appeal merely intended for the correction of the penalty imposed by the lower court, which when corrected would entitle the accused to apply for probation. And second, appeal is merely intended to review the crime for which the accused was convicted, and that the accused should only be liable to the lesser offense which is necessarily included in the crime for which he was originally convicted, and the proper penalty imposable is within the probationable period. Okay. So, what must be averred in the notice of appeal in the context lang of the probation? When the accused is convicted by trial court of a crime where the penalty imposed is within the probationable period of or a fine, the accused files a notice of appeal, and when the accused files a notice of appeal which puts the merits of conviction in issue, even if there is an alternative prayer for the correction of the penalty imposed by the trial court, or for a conviction of a lesser crime which is necessarily included in the crime in which he was convicted, where the penalty is within the probationable period. So, grant of probation. Even if a convicted person falls within the classes of those qualified for probation, the grant of probation is not automatic or ministerial. An order placing the defendant in probation is not a sentence, but is rather, in effect, a suspension of the imposition of sentence. It is not final judgment, but is rather an interlocutory judgment. When sentenced to imprisonment of not more than 1 year, probation shall not exceed 2 years. When sentenced to more than 1 year, shall not exceed 6 years. When sentenced to a fine and made to suffer subsidiary imprisonment, shall be twice the total days of subsidiary imprisonment. Okay, so the following are the criteria of probation, or what should be considered in deciding whether or not to place an offender under probation. First is the available institutional and community resources. So, meron pa bang paglalagyan kung ikukulong? May lugar pa ba sa mga kulungan? Kaya pa ba magpakain pa ng isa? Kaya pa ba yung guard to detainee or prisoner ratio? Okay pa ba? So, yung mga economic realities, no? And mga penal, mga what I'm trying to say is, depende yan sa Bucor or sa BJMP, no? If kaya pa yung reality. Baka sobrang dami ng kriminal, wala na mapaglalagyang kulungan. Next is the mental condition of the offender, his character, antecedent, environment, and physical condition. So, the following grounds are grounds for denying probation. The offender is in need of correctional treatment, best provided through commitment to an institution. Kailangan talaga siyang ikulong sa crime niya na ginawa. There is undue risk that the offender will commit another offense during the probation period kapag hindi mo kinulong yan. Baka may gawin ulit. Probation will depreciate the seriousness of the offense committed. So these are the 3 grounds why an application for probation may be denied. But once probation is granted, the execution of sentence shall be suspended for such period and upon such terms and conditions as the trial court may deem best. Probation does not extinguish civil liability, however. It only affects the criminal aspect of the case, and accessory penalties are deemed suspended. So, hindi ka makukulong. Pero may terms and conditions yan. Okay. Sorry kung meron akong strepsils. Probation orders shall contain conditions requiring the probationer to present himself to a supervising probation officer at the place specified in the order within 72 hours from receipt of said order. Kailangan andyan yung, pwedeng iba-iba kasi yung probation conditions sa bawat offender eh. Pero ito yung mga kailangan nandun. Pwedeng dagdagan, pero dapat may ganitong provision. So first is, yun nga, kailangan niya mag-appear. Merong naka-assign na probation officer yan. Kailangan niya mag-appear sa probation officer niya within 72 hours kapag sinabihan siyang mag-appear. Report to the probation officer at least once a month at the time and place specified by the said officer. Discretionary conditions, the two conditions above, well, yung I mentioned, are mandatory conditions. The rest, depende na, no? Are discretionary conditions. Di may sinasabi kung pwedeng dagdagan ng terms. So, sa probation law, check yung section 10. Meron mga conditions sa enumerate dun, but it's not limited to that. Pwede pa rin gumawa ng unique na mga discretionary conditions. Okay. Violation of probation order. Upon the failure of the probationer to comply with any of the conditions prescribed in the order, or upon his commission of another offense, he shall serve the penalty imposed for the offense under which he was placed on probation. So, at any time during the probation, the court may issue warrant of arrest of the probationer for violation of the conditions of the probation. Once arrested and detained, the probationer shall be brought to the court for a hearing of the violation charged. The defendant may be admitted to bail pending such hearing. The violation of a conditional pardon, different as a probation, constitutes evasion of service of sentence under Article 159 of the RPC. Well, the violation of the conditions of probation, which is different from pardon, must be serious to justify the issuance of warrant of arrest. Alright, so continuing, the defendant may be admitted to bail pending hearing. Hearing is summary in nature, but the probationer shall have the right to be informed of the violation charged and to adduce evidence in his favor. The court is not bound, but the technical rules of evidence must be followed. If the violation is established, the court may revoke or continue his probation and modify the conditions. So if revoked, the court shall order the probationer to serve the sentence originally imposed. The order revoking the grant of probation or modifying the terms and conditions thereof is not appealable. Okay, so order of final discharge. An order of final discharge of the probationer shall be issued by the court after the period of probation and upon consideration of the report and recommendation of the probation officer upon finding that probationer fulfilled the terms and conditions of his probation. The probationer and the probation officer shall each be furnished with a copy of such order. So, effect of final discharge. The final discharge of the probationer shall operate to restore him all civil rights lost or suspended as a result of his conviction, and totally extinguish his criminal liability as to the offense for which probation was granted. The expiration of the probation period alone does not automatically terminate probation. Probation is not coterminous with its period. There must first be an order of final discharge issued by the court based on the report and recommendation of the probation officer. So let's go naman to executive clemency. Okay. So it refers to commutation of sentence. One, it could also be conditional pardon and absolute pardon. These are granted by the President upon recommendation of the Board of Pardons and Parole. So commutation of sentence, reduction of the period of a prison sentence. So the Board of Pardons and Parole may review the petition of a prisoner for commutation of sentence if, if the following requirements are met. First, at least a third of the definite or aggregate prison terms are met. Second, at least 1/2 of the minimum of indeterminate or aggregate minimum of indeterminate prison terms was served. Third, at least 10 years for inmates sentenced to 1 reclusion perpetua or life imprisonment for crimes or offenses not punishable under RA 7659 and other special laws. At least 13 years of imprisonment for inmates whose indeterminate and or definite prison time were adjusted to a definite prison term of 40 years in accordance with the provisions of Article 70 of the RPC as amended. At least 15 years of imprisonment for inmates convicted of heinous crimes as defined in RA 7659 committed on or after January 1, 1994 and sentenced to 1 reclusion perpetua or 1 life imprisonment. At least 18 years for inmates sentenced to reclusion perpetua or life imprisonment for violation of the Dangerous Drugs Act, kidnapping for ransom, or violation of the laws of terrorism, plunder, and transnational crimes. At least 20 years for inmates sentenced to 2 or more reclusion perpetua or life imprisonment, even if their sentences were adjusted to a definite prison term of 40 years in accordance with Article 70 of the RPC as amended. And lastly, at least 25 years imprisonment for inmates originally sentenced to death penalty for which was automatically reduced or commuted to reclusion perpetua or life imprisonment. So now let's talk about pardon. Konti na lang guys kasi part 2. Make sure you watch the part 1 of this so that kompleto nyo yung extinction of criminal liabilities. Pardon is an act of grace by the President proceeding from the power entrusted with the execution of the laws which exempts the individual on whom not is bestowed the punishment the law inflicts for the crime is committed. It's a private act of the President, and under Article 23, pardon is extended by the offended party, not by the President. Iba to. Like for example, for adultery or concubinage, no? And the innocent spouse forgives the guilty spouse. And the paramour of the guilty spouse. So that kind of pardon is one which is extended by the offended party, and it extinguishes the civil liability of the offender, except under Article 344 that extinguishes also criminal liability. Under Articles 89, which is absolute pardon, and 94, conditional pardon, the pardon is extended by the President and not the offended party. That's different. And the criminal liability of the offender is totally and partially extinguished. Total extinguishment if absolute pardon, and then partial extinguishment if conditional pardon. but the civil liability is not extinguished. And a prisoner was served at least half of the maximum sentence of the original indeterminate and or definite prison term may be eligible for pardon. Conditional pardon is conditional exemption of a guilty offender for the punishment imposed by a court, so by terms and conditions though. Absolute pardon, total extinction. It is granted without any condition. Unconditional naman to. So, since it's granted without any condition whatsoever, it results to full restoration of even the civil rights. It does not alter the fact that the accused is a recidivist, as it produces only the extinction of the personal effects of the penalty, however. So one may file a petition for absolute pardon if the maximum sentence is served or granted final release and discharge of court, termination of probation. So now let's go to amnesty. So in amnesty, the person is released because his criminal liability is extinguished, as if he had committed no offense. So ito yung different sa pardon. Sa pardon kasi hindi siya na-erase. Sa amnesty, parang wala ka talagang ginawa in the first place. It makes an ex-convict no longer a recidivist, diba? Because it obliterates the last remnant of the crime. Sa pardon kasi, may ginawa ka pa rin. May record ka pa rin. Pwede ka pa rin maging recidivist. Sa amnesty, para siyang justifying circumstance. Wala ka talagang liability. So amnesty is made as a proclamation of the President with the concurrence of Congress. It is a public act of which the courts should take judicial notice. So last two topics, we have allowance for good conduct which culprit may earn while undergoing preventive imprisonment for serving sentence. So allowance is a granted to any person in penal institution, rehab, or detention center and other local jail, except if the prisoner is a recidivist, habitual delinquent, escapee, or charged with a heinous crime. So the computation of preventive imprisonment for purposes of immediate release shall be the actual period of detention with good conduct time allowance provided if the accused is absent without justifiable cause at any stage of the trial. The court may motu proprio order the rearrest of the accused. So appeal does not deprive entitlement to good conduct allowance, unlike in probation. The director of Bucor, or chief of BGMP, and wardens of provincial, district, municipal, and city jails may grant time allowances under Article 97-98 of RA 10592. So first 2 years in penal institution may result to entitlement of 20 days deduction from sentence of each good month of behavior. 3 to 5 years in penal institution may result to entitlement to 23 days deduction from sentence for each month of good behavior. 6 to 10 years in penal institution may result to entitlement to 25 days of deduction from sentence for each month of good behavior. And more than 11 years in penal institution may result to entitlement to 30 days deduction from sentence for each month of good behavior. And any time during period of imprisonment, 15 days deduction from sentence for each month of study, teaching, or mentoring service time rendered. And the last topic that we have is special time allowance. is the deduction in the period of sentence of a prisoner during the calamity or catastrophe. Special time allowance for loyalty applies to any prisoner, whether undergoing preventive imprisonment or already serving a sentence. So when a prisoner having evaded his sentence gives himself up to authorities within 48 hours following issuance of proclamation by President announcing the passing away of the calamity, 1/5 of period of sentence may be deducted. And when a prisoner chooses to stay in the place of confinement, and 2/5 of the period of the sentence may be deducted. Okay, so that's it for Crim Law 1. I'm just gonna share a recitation question asked sa akin by my professor, Justice Tang of Sandigan Bayan. So she asked me what happens if were there any criminal liabilities incurred by prisoners and by the warden if, for example, there was a catastrophe and the warden himself, so let's say the catastrophe, yung sa example sa akin nun was flood, the warden told the inmates that they should leave. The warden opened the gates and told the inmates that they should leave because binabaha na. And if hindi pa sila umalis, delikado. So the inmates, they all fled. And hinayaan lang sila ng guards on the direction of the warden. So after a day, mga roughly 24 hours, some of the prisoners went back to jail. Their reason is that they have nothing to eat outside. They're hungry. At least in jail, they have something to eat. So that was their motivation. So, what are the criminal liabilities, if any? And I answered that there's no criminal liability on the part of the warden, and there's also no criminal liability on the part of the prisoners. No crime was committed. First, in the case of the warden, there could have been a crime. Merong crime yan I forgot which, pero yung pag nilet go mo yung prisoners, you just check what crime it is, pero definitely merong crime yan. Kasi may ano yan may responsibility yan si warden na i-make sure na hindi makalabas or bawal niyang palabasin, diba? Bawal niyang i-assist yung escape ng prisoners or i-facilitate yung escape ng prisoners. So there's a crime for that, definitely. However, there's no criminal liability because there's a justifying circumstance. That justifying circumstance is avoidance of greater evil or injury. So what is the sure, it's bad that he let them go, but he was trying to avoid the greater evil or injury, which is the death of the prisoners if hindi niya pinalabas kasi binabahan na and that was what he did, was the lesser evil. So no criminal liability kasi may justifying circumstance siya. Sa prisoners naman, umalis sila because of an order. So, wala silang criminal liability. And, ayun na nga rin, binabaha na. So, same concept lang din. So, there was a lawful order. And, ayun, they were also trying to save themselves. So, justified pa rin sa actions nila. Now, since yung pinag-uusapan natin is special time allowance. And, diba sabi natin earlier, if prisoner naka-escape, okay, due to, say, for example, a calamity or catastrophe, but gave himself up to authorities within 48 hours following the issuance of proclamation by President announcing the passing away of the calamity. So, case natin dito, bumalik sila 24 hours after the calamity passed. Assume na lang natin na may issuance of proclamation na rin si President na wala na yung calamity. Safe na. 24 hours, pasok yun sa 48 hours. So, entitled sila sa special time allowance. And yung reason nila ba't sila bumalik, which is dahil gutom sila, is immaterial. Because there's nothing in the law that states that they have to have good intentions for them to return. You know? And if their intention is food or hunger, doesn't matter. They're still entitled to 1/5 of the period of sentence deduction. Okay. So, yan. I hope you also learned a lot sa Crim Law 1 discussion natin. For Crim Law 2, okay, ayun na, tapos natin yung Crim Law 1. For Crim Law 2, let's start on November na. So, what can you expect dito sa channel this October? Polyrev, Consti 1, and Property. Yan. For November naman, Crim Law 2, Consti 2, and probably other topics in political law. Basta ubos natin yung political law by December. Pati public international law. And yung sa civrev naman, succession. Magsa-start na tayo sa succession November up to December. So, thank you and take care, guys.